Yeah, Lisa and...
Hi, I just have a question. I'm married to an alcoholic knock, which just is a double whammy. In terms of, and we also married out of community with the accrual. So all my jewelries and gifts that I was given prior to marriage, is that still his property or is that mine?
Yeah. So gifts, there's a word, if I can just remember, but it's an old Latin word that they use to describe the nature or that category of asset. But gifts are yours. It is excluded from the joint estate or the joint property. So anything that you can demonstrate was given to you as a gift, right? That would form part of your estate and not his estate. But the challenge with that is, obviously, in terms of the calculations of the accrual, because remember, when you calculate the accrual, it is based on what your estate value is, the value of your estate and the value of his estate, and then the difference in accrual is then split between the parties, whoever has the greatest accrual. So if you show a greater accrual than your spouse, then that difference in accrual gets split 50-50, right? And then it gets given to, or it gets distributed to the spouses. But when it is gifts that were given to you, that does not form part of the joint estate.
So, for example, my engagement ring, that would be, it's mine. I mean, he gave it to me, so it's not part of the
joint estate.
Yes. Okay.
Yeah. Essentially, that should be that is a gift that was given to you. So it is part. Any gifts that they give to you prior or during the course of the marriage is considered your personal property and not part of the joint estate.
Okay, and just the other...
And another thing, usually, when you enter into a marriage out of community of property with the accrual system, you draft an anti-nuptial contract. And in that anti-nuptial contract, you stipulate what is the estate value with which you are entering into this marriage that forms part of the joint estate or should be excluded from the joint estate. Now, usually in that document, you would have listed those things that you come into the marriage with which you deem to be excluded from the joint estate. That's why an anti-nuptial agreement is so important, is so that you can indicate what forms part of the joint estate or from what point, or what is excluded from the joint estate at the time you enter into marriage.
Okay, and then the other question is, the house that we currently live in, he inherited from his late mom, so we live there now. Before we got married, this is what happened before he got married, he got the house, and I think it was valuated, let's just say, at 1.5 million. If we had to get a divorce now, in the house is now valued, let's say, 2 million, would that 500,000 be part of the accrual?
Yeah, so two things. Number one, if in your anti-nuptial agreement that you entered into prior to getting married, if that is not stipulated as something that's excluded from the joint estate, then it would form part of the joint estate. Secondly, if the will from which he inherited the house stipulates that the house should be inherited free of marriage in community of property or accrual, then of course it would also be excluded from the joint estate. If none of those things exist, then it will form part of the joint estate, and then of course part of the accrual.
And sorry, last question. So he's very, very smart, and obviously everything is in his name. Bank cards, all of that, financial matters. And when things get really bad, he's very quick to say, well, if you don't like it, you can leave. He knows I have nowhere to leave to. By law, can he do that? Can he literally lock me out of my house or our house?
No, you are married. That's where you live together. And you are also protected by our eviction laws, right? Even though you're not a tenant. But the laws that regulates occupancy of domestic dwellings also protects you. So essentially putting you out is evicting you, and he would be contravening the law because you can't evict somebody without a court order evicting that person from the property. So that's one area of law that protects you as an occupant of that premises or that property. And the second thing is that you are married, and it is for the court to determine if, in the absence of a clear antenuptial agreement defining which constitutes joint or which constitutes the property over which you would be sharing accrual, then that means that he has absolutely no right to put you out of that property, because that property could essentially terminate, dependent on the accrual and the division, be a property that you would be entitled to share in, right? So he cannot evict you from that property. If he obviously does that, if he puts you out, let's talk about physical things, right? So I'm putting you out of the house. You're out now, okay? It's not a legal process here. This is something that's physically happening right now. What do you do then? So under those circumstances, you can obviously go and approach the police to say that you have now been put out of the house, you live there and you need access, and the next morning you can obviously go to the court and apply for a protection order, because a protection order can also order that you be granted access to your dwelling, to your joint dwelling, as much as you can also get a protection order that gives an order that the person that you don't want to access the property then be ordered by the court not to access the property, right? So you can also get a protection order then the next morning to get an order that you be allowed back in your dwelling.
And I promise, last question.
Yeah.
Somebody that's not an attorney or have experience in that, all right, so let's say he suddenly decides to serve divorce documents on me.
Yeah.
And I don't have the financial means to go to my attorney. What is my first, what do I do? I've got this document, you've got a certain amount of period to respond to, and or so as somebody who has no experience in this, what is my first step?
So the first step is when you receive a summons, whether it's going to be a civil summons or a divorce summons, any kind of summons, ladies and gentlemen, it's important to ensure that within the stipulated time frame in the summons that you enter an appearance to defend. Okay? Because that indicates that the matter is going to be challenged by you. It's going to be disputed by you, right? So that you are then afforded an opportunity to state your side of the story. So that's the first thing that you would do. The second thing, of course, is that when you look at the summons, focus on the particulars of claim. In the particulars of claim, that's where you'll see what the person is saying about you. And lastly, it ends off with prayers, saying, what does the person want? Okay, so if the person, for example, simply says, I want a divorce decree, the division of the joint estate, or whatever the case, might be, and it's something that you don't really disagree with, then of course, I mean, you can let the divorce proceedings proceed without opposing it. But if the divorce document stipulates things that you disagree with, and they want prayers that you are not in agreement with, then of course you've got to, enter an appearance to defend. My approach is always, even if the summons doesn't necessarily contain stuff that you wouldn't want, and you don't necessarily feel like you want to challenge any of the things that are contained in there, my advice is always to enter an appearance to defend, because you must always exercise your right to natural justice, your right to state your side of the story. So I suppose my response to your question then is simply, when you receive a summons, make sure that you read within how much time and to whom you need to file your notice of intention to defend. Usually the address would be made available on the document, or it will give you the option to do it at the court itself. If you're a layperson, you can physically go to the court. There's a little stub usually in the summons that you can just fill in, which is a notice of intention to defend, and you can get that stub submitted to the court out of which that summons was issued. That's also very important. You can't just go to any other court. You must go to the court out of which that summons was issued. It will usually tell you at the top of the preamble, in the High Court of South Africa held at Johannesburg, or we would say in the Magistrates Court for the Regional District of Brakpan, or whatever the case might be. So you need to make sure that you enter your appearance to defend out of that relevant court.
And when does the Rule 43 come in? Because now I would need to see an attorney.
Certainly.
So
you can immediately launch at that point an application in terms of Rule 43, because now you're going to have costs, fees, isn't it, for defending this legal action. So you can lodge that application at that stage.
And I can do that directly with the attorney. Can I go to an attorney and say this is what it is?
Ideally, it's best to approach an attorney to help you with the Rule 43 application. I would recommend it. And then obviously the attorney can then proceed to do that for you. Okay.
Everything is in his name. That increases his accrual, right?
If everything
is in his name,
yeah,
it increases her accrual.
It increases his accrual. Yes, absolutely. Absolutely. That's right. That's right. Yes, ma'am.
Hi, sorry, Ronelda. It's really, really interesting
Hi,
what
Kim.
you're saying, and I'm really enjoying it. Thank you so much. I would just like to ask if, taking Lisa's whole scenario into the package. So
Yeah.
everything is in your husband's name. He's got everything. So there you are. Plus you are an employee of his company.
Okay.
What happens then? Because then it goes to employee rights. So one is employee rights and one is marital rights. How would you distinguish between the two?
I wouldn't even talk about the two in the same sentence, because the one is distinguishable from the next. Because in terms of the employment relationship, there is a formal employment relationship. It's a formal contract of law that gives rise to certain rights and obligations, okay? And a marriage gives rise to certain rights and obligations. So when we talk about the employment relationship, distinguish it, okay? You yourself, in your mind, in your thinking, distinguish it. Because if you're going to start thinking about, but we married in community of property and what happens, don't think that way. Think separately about it, because there's a different employment relationship. It's regulated by the Labour Relations Act. It's regulated by the Employment Equity Act. It's regulated by the Basic Conditions of Employment Act. It's regulated by the Constitution as well, in terms of your rights that you have. So when you think about your rights and what you can do in terms of the employment relationship, refer to the laws that regulate the employment relationship. Okay? So, and your recourse also is different, because if you have a dispute against your employer, where do you go? You go to the CCMA or the bargaining council. When you have a dispute against your husband and you want to leave him, where do you go? You go to the civil courts, right? So the recourse is also different.
I understand that, but
Yes.
per se, obviously your husband hasn't followed due process and procedures in terms of your employment. So
Yes.
you don't have an employee contract. You have absolutely nothing in
Okay.
place. You don't earn a salary, nothing whatsoever. So
Okay.
as I would say, it's not in the books.
100%. Okay. So, and I hear where you're going, is you basically helping in your husband's business. So you see it as an employee relationship, but your husband's probably is seeing it as your duty and responsibility as my wife to help me and help out. And so here's the thing. When you look at the definition of an employment relationship, this is the definition, right? It's any situation where one party presents him or herself into service, or to provide a particular service, to assist and further the business interest of that employer on the one hand, and on the other hand, an undertaking to remunerate that person in exchange for the provision of that service. Now, what you're basically saying is that only the one element is present, but the other element, in terms of an agreement to remuneration, that's not present. Right? That's essentially what you're saying. So under those circumstances, if you can't prove the existence of the employment relationship, which you would be required to do if you want to make use of the remedies available to you under the employment relationship legislation, when you go to the CCMA, you will have to prove that there is an employment relationship. They only protect employees that are in an employment relationship. So if you are unable to prove that there is an employment relationship, then you would not be able to have access to the remedies available to the, in the CCMA. Now, how do you prove the existence of an employment relationship? Section 200 of the Labour Relations Act has sort of like a definition, but it's again linked to remuneration. But remember, payment in kind in terms of the Basic Conditions of Employment Act is also a form of remuneration, okay? I think if you would like to make use of, if your question is whether you have recourse as you view yourself as an employee against your husband's company, what can you do under those circumstances? So I would suggest have a look at Section 200 and see what are the factors there, because there's a couple of factors. Like if somebody demands of you to present yourself for service within certain time frames, or they require you to deliver a service within certain time frames, if they control what you do, if they demand certain things from you, so there are certain factors listed there. I think there's about 8 or 9 factors listed there. If any one of those factors are present in terms of the South African law, you are deemed an employee. Okay, so have a look at that on the one hand, yeah. And on the other hand, if you are proceeding to divorce, I don't know if that's what you're planning on doing, but you haven't said that, so I assume you're probably not going that route. So, but in the interim, I suppose, yeah, maybe is your concern predominantly around the employment relationship?
It's the whole package. So it's just a case of being forewarned as forearmed.
Yeah.
Can I? Dealing with a narcissist, I mean, you're dealing with a spiritual vampire. So their mentality is they actually, I don't know how they have it, but they actually have a way of reading your mind. So you just want to be forewarned as forearmed. So
absolutely.
if something should come, that you are actually
protected.
You're a little bit legally savvy in your own mind that if it does face you,
Can
what
I
to
ask
do.
a question? Can I ask a question? Do you formally report to the business premises? Do you go to business premises, or is it an informal company operated from home? Okay.
Yes, I go to work. I actually go to work.
Okay, so you basically report for duty.
Yes.
You see, the elements of an employment relationship is present. So you probably will be deemed an employee, and you would be able to have recourse to forums such as the CCMA. And in the interim, if you don't have a dispute like an unfair labor practice or an unfair dismissal claim, you can approach the Department of Labor that your employer is not complying with the law because they haven't registered you, they haven't given you written particulars of employment, they are not registering you for UIF. So you can go to the Department of Labor and say and make a complaint against the entity, because it's not going to be the individual, because your husband operates under a corporate entity, right? It's going to be something PTY Limited, it's going to be something CC, right? So you're going to go and report the company that is transgressing the labor laws of the country. Okay. Thank you so much. Hi, Fatih. I know you. Hi.
Yes, I know
How
you.
are you?
Can you? So just comment first and then questions. There was a comment about the Pretoria High Court. They do take applications.
Yeah.
I did one in July for an urgent, and it was heard virtually.
Virtually heard. Yes.
Yeah.
Yes. 100%. Thank you. So there you.
Yeah. So in terms of being exposed to a narcissist who's also in the legal profession and who's manipulating the system, what sort of recourse and intervention do we have there?
Yeah. So I'm a little bit familiar with Fatima's case. The obvious answer that I can give is, if your presiding officer demonstrate any bias, you have the right to bring an application for recusal. Okay, that's now before the judge has made a decision. Okay, but if you feel uncomfortable and you feel that the conduct that is being displayed is conduct that seems to disregard anything you say and simply accept what the other party is saying, and you just feel completely uncomfortable being heard before that presiding officer, you do have the right to bring an application for recusal. Okay, if, however, you have two scenarios that come as a result of that recusal. Let's say one, the recusal application fails and the judge proceeds with your matter. You do obviously again have recourse to lodge an appeal against the decision that had been made. Okay? Then obviously you could also file a complaint with the judge president of that particular court to raise whatever your qualms are, how that presiding officer has handled the matter. if it hasn't reached that point and or if it's post that, when a decision has already been made, you didn't file a recusal application, but you've noticed from the judgment that this judge clearly came to a decision that no reasonable decision maker would have come to, and has actually not made a decision that's justifiable and that is fair, okay? Because it failed to take into account your evidence. It ignored your evidence and simply focused on the evidence on the other party. So if you believe when you read the judgment of that particular judge that these are the kinds of things that comes to the fore, again, appeal. You can appeal that outcome. And you can obviously also lodge a complaint against that particular presiding officer, a formal complaint with the judge president of that particular court. Okay, and obviously if that doesn't assist, then you can obviously escalate the matter as well. The Department of Justice and Constitutional Development, you can also lodge it there. The Public Protector, again, there are different, forums that you can, and depending also on in which regards or in which respects that behavior played out. If it's unconstitutional behavior, for example, you can even go to the Human Rights Commission if there was a breach of your human rights and lodge your complaint at the Human Rights Commission. But yes, so if the judge is not impartial, and if the judge seems to be biased in favor of the opponent with whom you are in litigation, then there is that recourse that you can have access to. Okay.
Okay, so just commenting on that, what happens if the judge refuses to give reasons? And in terms of the appeal, if you do a notice for leave to appeal, is there any specific timelines in which they need to respond to for the hearing date?
Yeah.
And in terms of the other avenues that one could explore, I don't think one actually gets much recourse in those particular areas either. Because if one goes to Department of Justice, they just refer you to Chief Justice's office, and there's no recourse there. So,
yeah. So, when a question was posed to me earlier on about there are all the legislation, there are all these processes, but what happens if an official that is a custodian of these processes does nothing about it, doesn't adhere to it themselves, flouts it themselves, disregards it themselves? What do you do? And that's sometimes a reality that some people end up facing. And that's unfortunate, because those laws exist exactly so that we are able to have recourse and have access to justice. So if those principles and those laws and those regulations are flouted and not adhered to and disregarded and not overseen, where do you stand? What do you do? What do you stand to do as an individual? So I suppose to then respond that when you've lodged a complaint and it goes unheard and it goes ignored, it's to escalate it, unfortunately, to escalate it to the next level. I know some individuals even end up writing a letter to the president. But really, some people get so desperate because every other platform, the ministry that is overseeing that particular discipline ignores it, and it doesn't do anything about it. Where to next, right? So I suppose all I can say is that when you've followed a certain step and there has been no remedy, then you're probably going to have to escalate it to the next level until you get joy. If the Chief Justice to whom you've lodged the complaint has done nothing about it, you've got to escalate it. As far as the appeal question is concerned, whether there should be reasons provided with it, I know some judges never provide the answers, or the reasons rather, for their decision, forcing litigants to formally bring an application in court to compel them to provide written reasons. So if you are finding yourself in such a scenario, one possible avenue could probably be to bring an application to compel.
So they give a judgment, but the judgment doesn't have reasons. So
yeah, yes, exactly. So under those circumstances, obviously you start off by writing and requesting the judge to provide the reasons. And if that still goes ignored, then of course you can exercise the avenue of, as I say, to bring an application to compel.
What I'm saying is that when you request reasons,
yes,
their reasons actually don't give you any reasons.
Oh, okay. it's not satisfying in any event. Yeah, okay. So look, under those circumstances, and that's in the appeal process, right? That's during the appeal process? Even before the appeal process, yeah. Yeah. It's a matter of interpretation whether the appeal provides reasons or not, I suppose, hey? It's a matter of interpretation. Yes.
So yeah, and just in terms of the timelines, what's a number of days?
To provide reasons?
No, in terms of if you do a notice for leave to appeal, and for them to give you a court hearing for the...
I don't know. It will really depend on the directives. Obviously it's stipulated in the practice directives what the time frame is. So I can't off the top of my head tell you now for appeal how many days it is.
Okay. But what really recourse is there if the same judge ends up hearing the notice for leave to appeal? That seems to be the norm, but logically it just doesn't make sense that the person who granted an order needs to hear your leave to appeal that order.
Yes. That is the norm, and that is what happens. If the appeal is rejected, then you can obviously take it to the Supreme Court of Appeal. You can still appeal or bring your appeal or apply for your appeal, even if the judge who presided over the matter rejects your request for to grant leave to appeal. You can escalate that. Yes, ma'am.
Okay, I'm asking a question on behalf of a member of the group, but she's not here.
Okay.
So what happened was her narcissist went into court and lied and talked absolute rubbish about her and put a protection order against her. Yeah. So she's looking after her kids. She's got a protection order against her. And her question is, does this put a black mark against her name? And how can she actually sort of get rid of that?
Certainly. So there are steps in the protection order process. Firstly, it will be an interim protection order, okay? And then it will have a return date. And on that return date, she should attend at court, because that's the opportunity where she can defend herself against those allegations and disprove it. So if it is based on false, if it's fallacious, then of course that is the platform where she would be afforded the opportunity then to defend it so that it is not made a permanent or final rather, so that it's not made into a final order.
Okay, and she also asked whether there's finances, big money involved in doing that.
So, look, it's in the magistrate or the regional court. So, if she's going to enlist the services of a legal professional, it's going to cost her. But if she does it on her own, you access the courts for free. They don't charge you any fees. There's no admin fees or any fees that you get charged if you use the courts. Even the tribunals, like the CCMA, for example, there's no fee that you pay. So there would not be any cost involved if she does it herself. Of course, if she enlists the services of a lawyer, and if it's not a pro bono lawyer, then of course that would be the legal costs that she would have to incur. Yes. Yeah.
I'm sure a lot of people have the same problem. When you have a statement from somebody that is a complete and utter lie and can be proven so, what recourse do you have to deal with that after the event? If you have a case dismissed or in our case discharged, but there are blatant categorical lies in there, what is your recourse for that? What is the legal action you can take against that person? Is it slander?
Yes, certainly. Okay, so first and foremost, when somebody perjures themselves or writes proven lies or misinformation or misrepresentations, that can constitute an act called perjury. Right? So it is a criminal offense. So you can institute criminal action against that person if they have done that and you've got evidence to support that contention. On the other hand, if it was comments made to you which shall we say constitutes injuria, in that it is defamatory to you, then you could potentially, and this is an area of law that is very, I almost want to call it, it's difficult, it's complex, but you can also consider the possibility of a defamation claim against that individual, right? Remember, the keys with defamation is that there should be an element of publicity. It should have been publicized in some way or the other, okay? But once you can demonstrate that, and secondly, that the person was aware that what they are saying constitutes lies or untruths. Yeah. It can be absolutely, it can be accessible, yeah. So you can definitely consider that as publication. Yes, ma'am.